being transcribed. This meeting is being recorded.
Reminder for everybody speaking to the mic. I want to welcome everybody to our committee meetings being held today. And so the one thing I'd like to start off with is that obviously we're here in Nashville, and obviously there are some bad weather being currently suggested for in the morning that could bring us some ice and freezing rain or snow or who knows what else. And obviously in Middle Tennessee, it's not quite prepared, although better than Memphis for something like this, but not as good as East Tennessee. So the question is that we have to have 5 people here. Is that correct? 6 people here.
6, yeah.
To have a quorum. So the logistics is kind of this way. If something happens and the state cancels everything tomorrow, we'll all get a phone call like we normally do on our phones. And that could be so far as that we're going to close the offices in Nashville in the morning, or it's going to be delayed. So if that happens, we'll probably be on a delayed schedule. If they say they're closing the offices tomorrow, we cannot meet, period. So our meeting will be deferred or canceled this time, and then we'll meet at our next meeting for everything. If we were to have an ice storm in the morning, the question is, who here thinks that they can get in? Are they in proximity of a hotel, or do you feel comfortable driving in? And if you don't, please do not drive in. But let's just go around the room and say, we'll start with Robert, and we'll just go this way, and then we'll go through the staff and say, if you think that you're in that situation, will you be comfortable coming in the morning? Okay. Well, like I said, if it do not feel bad.
If it's really bad?
Yeah.
No.
Okay, good. All right. Because we don't want anybody to get hurt, period. So, and I think that between Robert and the 3 of us are staying downtown, so that's 4 and 5. So we only need 2 more. So
I'm planning to try to make it in, if it's passable. So.
Okay. Same, the 3 of us.
You can only make it if I bring you. So.
We're going to slide down the hill and get here. And John. So, David?
I'll be here as well.
Okay. And Pamela? Possibly not. Okay. And if that's the case, I mean, we still can jump in and have a virtual meeting with y'all on it, which that we just have to have a quorum present. Is that not correct, Wendy?
Correct. So a quorum is necessary in the room.
Okay.
And if we are able to achieve that, we could still have the meeting and other people could join remotely.
Okay. So it looks like that we may have a quorum. Judy, welcome. Good to see you.
Thanks. A little delayed due to the traffic down there.
Oh, that's a mess. Yeah. They let us by, so we didn't get caught there. I thought we were going to get caught, and they motioned some by. So the question today is just about the weather tomorrow. Do you feel like that if it's bad weather, you can get in? And if you don't, otherwise, those who can't get in were saying, hey, just virtually come in.
I know nothing about the weather tomorrow. What's it supposed to do? I don't know.
Ice
Ice.
in the morning.
I have all-wheel drive, so I probably can get here.
Okay. All right. And just whoever said they were coming, if it becomes an issue, please take the safe crowd. That definitely go on that side and not come in, because we don't want anybody to get hurt.
So, Andy, at this point, would you like to stay with an 8:30 meeting, or would you like to give a little bit additional time?
I kind of think that if we give a little bit of additional time, we might be able to get everybody here and be okay. Because I think that my personal opinion is that even looking at the weather, that the ground's too warm. Now that's what we'd say in East Tennessee. It's not cold enough for it to stick. But Nashville has when it ices, people just don't drive good in it. Whereas we kind of get around up there. I don't know how, but we do. Maybe it's the fact that there's ice and then there's snow on top of the ice. I don't know. But I definitely, we have drivers who are used to driving on it, and I think that's the key, that people have space, they go slower and so forth. With that said, I know our agenda tomorrow is not as large as we normally have. We have canceled breakfast so that you don't have to come in early to eat breakfast. So what would y'all think of a 9 or even a 9:30 start in the morning, kind of postponing it to give the weather a chance to kind of clear and it to warm up a little bit? But I don't think that we were kind of seeing a little bit of warm up, weren't we, by about 9:30, about 11? But it might give the trucks or the crew people, the highway people, a chance to get out and put down the salt or the liquid to get the ice off the road. So what are your thoughts about that? What would you prefer, Wendy? Because I think that staff is probably the people that are coming in the longest way.
Yeah, yes, for me,
This meeting is no longer being transcribed.
being 45 minutes to an hour away, a little bit of a delay would be helpful.
Would 9:30 be better for you? Okay. Or we could go 10, because I really don't think we'll be much over 12 if we go to 10 o'clock.
Yeah.
One consideration, though, is there's supposed to be kind of a second batch coming in tomorrow afternoon and evening, and so I'm a little worried if we start too late for the people that are trying to drive home.
Okay. That's a good.
Or maybe 9:30 is a good compromise.
Let's shoot for 9:30, and then that'll also give us all time to see what's happening in the morning.
Okay.
And we still have an opportunity to delay further if not everybody's here and we can't get started. Let's say that.
Well, why don't we just say that everybody watch for your emails about 7:30 in the morning, and Wendy, if you'll just keep us up to date of your thoughts and what's going on and what the weather is. And
Let's plan for 9:30. We can contact Mr. Ash or Mr. Culpepper's attorney. But let's plan for 9:30, and then stay tuned to your email. I'll let you know if things look different.
Can I just say, hallelujah, there's no screens?
Yeah.
I don't know if anybody else noticed, but I noticed that a lot.
now the question is, did you bring the little candy things again?
Woohoo, we're back to normal.
Yeah. Okay, well, welcome everyone again. Glad that we're all here, and we're going to start with the licensing committee. Pamela, our chair, is going to take over from here, so I'll turn it over to you, Madam Chairman.
Dr. Church, could you pull your microphone down really close? Yeah, and make sure it's on speak, please.
Okay.
There you go.
How's that?
Perfect.
All right. We have several today. So let me make sure I am on. We're going to start with Lawson. This is Tyler Lawson. Mr. Lawson passed BEC September 29th, 2021. Will expire March 29th, 2023. He's requesting a 6-month extension until September 30th, 2023 due to a divorce and mental health issues, and has provided ample documentation to support those. He estimates that he lost 6 months of preparation time from his separation from his wife to the divorce. I would suggest that that may be a modest estimate, because I'm sure he's been through a lot. He's provided documentation from a medical professional to describe his significant hardships and diagnoses of specific mental health issues. And I move that we grant this 6-month extension as
there any discussion among the committee members?
I'd like to say that tomorrow when we vote on these, I will abstain from that one because I know him.
Vote.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Second one is Nathan Nelson. Mr. Nelson requesting an extension of his auditing score until December 3rd, 2022, which is only 19 days. You'll see why. As a result of a publishing error as to when scores would be released if he sat for FAR on October 1st, 2022. As you know, there are blocks of months where the scores are estimated to be released at the same time. We had a case last time where someone simply argued that there was a significant delay beyond what the AICPA had published as the estimated score, and he planned according to the date that had been published. And we discussed that at length because the AICPA, at least some places, states that this is an estimate, but it's still a published date. So this one is different because they should have cut off the window when they published that date. They should have cut it off at September 30th as that block released together, and instead they went to October 1st. So he believed that if he sat for FAR on October 1st, he would receive his score by October the 11th, which would give him one more opportunity to pass his final part, FAR, before auditing expired. The October 1st date was incorrectly published, should have read September 30th. The error was corrected without any advance notice, so he was not aware of that correction. Since that time, the candidate did pass FAR, so my understanding is that he took it, he failed it, he scheduled it again, and that was after he found that he passed it after auditing had expired. In other words, he received a failing FAR grade, then scheduled another testing opportunity and passed, but too late to keep auditing. We had been warned about this typo, by the way, and knew people would probably ask for extensions. So in this case, I move, well, before I get to the moving, let me say this. I said last time, and I have said this time, I wish the AICPA would go to the policy of, if they insist on publishing a date, I wish they would, every place it's stated, say scores are generally released, 6 to 8 weeks after the test date. However, there are sometimes delays, so please plan accordingly. And that would put the candidate in the position of knowing that it is just an estimate and that he or she should plan based on the fact that it's an estimate. With it's sort of a table and a date, and it just looks very official. Some of the CPA review services publish it as if it's a done deal. And so it's not right that people pick it up and run with it, but we want to give candidates the best opportunity they can have. Anyway, I move that we grant this extension. We granted the extension at the last meeting after much debate because the scores had been delayed significantly past a published estimated release date. And I think that the extension for Mr. Nelson is even more warranted because there was an error in the publication of the date that contributed to the inappropriate test scheduling by the candidate. So I move.
Second.
Motion and second. Any discussion?
Okay.
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
All right, this next one is Kavita Najawin. She's requesting a 6-month extension on FAR to October 8th, 2023 due to an accident, a fall, which led to a broken arm, nerve paralysis, and several months of recovery. She provided extensive documentation in which she described a prolonged recovery period, not being able to use that arm, which is her dominant arm, for quite a while. She said her mental concentration was affected due to the pain, injury, prolonged recovery, and inability to use my right hand to write, etc. She requested and was granted an extension on her notice to sit for auditing by 90 days from May 14th to August 14th, 22, but then had to cancel that one because she was denied a second extension. She reapplied for the auditing notice to sit and was finally able to sit for the auditing exam on October 29th, 2022. She states, given the extreme hardship I experienced from November 19th, 21 to July 27th, 22, due to my accident, I request you to mention our exam credit by 6 months to October 8th, 2023. So the period she describes is 8 months, and she's asking for a 6-month extension. She has been actively pursuing the exam. She has passed another part. Wendy actually pointed out that she is working in the tax area and would also have that demand on her time, but we don't usually consider work demands, and she did not mention her work. But it just seems like very fair request to me. And like I say, it was not just a broken arm, if that's a just, but it was nerve paralysis and pain pills and extensive pain, etc. So I move that we grant the extension.
Second.
All right, we have a motion and a second. Any discussion?
I'll ask a question here. I'm not on the committee, but I always have concerns. Now, first of all, I'm totally sympathetic with what she's been going through. But just putting all that aside, I always don't understand when candidates ask for an extension 2 or 3 months before their time. I mean, she's got
This is the one that I said was a preemptive request, wasn't it?
We're in almost February, and she's got until April to.
I can sort of understand it because it might affect her planning and remove some of the stress. I think she's been through significant stress.
Also, isn't she in tax? She is not going to have any capacity.
Spoken as the.
I mean, so to me, that's reasonable. I mean, she's smart to go ahead and ask for it.
Well, and I think, in order to study, you have to have clear mental concentration, and she has stated that that has not been the case. I think I understand what you're saying, and Wendy and I discussed that she's asking before she's even up against it. But I guess, it just helps her along the way.
She might not have had time to even ask for it in April because she's going to be working pretty hard the next few months. So this was probably her way of getting ahead of the ball.
I don't think she spoke extensively about exactly how she handled her work. Did she, Wendy?
No.
So she stayed away from that, and maybe she knew that we don't usually consider work obligations because we just can't assess those and compare those. But
Maybe that will keep her from having to go get counseling and release some anxiety on her part.
I think that the mental clarity is huge.
I agree.
I really.
I think she's going to be a good accountant if she's planning ahead that far.
And able to handle a broken arm for tax season. There you go.
Any other discussion? Seeing none, Karen?
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Right, the fourth one is Feng Yi Zhou. The candidate's requesting an additional extension on Reagan Farr until 6/30/23 due to continued travel difficulties in China from COVID-19. She provided many pages of support for her request, including local restrictions, travel requirements, pricing of flights, COVID breakouts at her office, etc. There was a change in December that will allow her to get a visa in the future. She tested in 2021, which was after the pandemic, but she was in the States then, and she went back to China and has not been able to leave China since that time. So I will say we have not really tried to scrutinize the details of the international travel issues. We all know they are significant. I would move that we grant this extension because I don't think we can differentiate too much. I mean, she provided, let me just say, I'm not saying anybody that asks will give an extension. She provided a lot of documentation. Certainly it seems comparable to other cases we have seen. So I would move that we grant it.
I'll second.
I have a motion and a second. Any discussion?
This is Janet. Is this an extension for Reg and Farr, or
Yeah, that's what I wrote down. Let me
or
call
Reg
up
and
the file.
Reg and VEC?
I'm
Doesn't
sorry.
look like she passed Farr.
Let me pull it up. Oh, you know what? I did indicate there was an error there.
Yeah,
I was copying the notes.
it should be BEC
Yeah,
far. Sorry
yeah,
about that.
Yeah,
VEC, okay.
you are right. And I made myself a note, and then I forgot to look at my note. So
Okay.
thank you, Janet.
Sure.
BEC reg.
Because the note says Reg and Farr were previously extended to 12/31/22, but it would actually be BEC and Reg.
All right, so for BEC and Reg, correct?
That's correct. So
Okay.
I move that we grant her requested extension.
All right, any other discussion?
I just have a question, not about the issue really, but why are these Chinese individuals in the state of Tennessee testing in the state of Tennessee? Are they working here? I'm just curious. Do we know?
No, typically no. Typically they are what we classify as foreign nationals, so they are not in the States. They are studying and testing internationally
Are they declaring Tennessee their residency or something like that?
Not a residency, but in order to become a licensed CPA, as we know it, certified public accountant, you have to do it through one of the states. So there isn't a federal license or an international license. You have to do it through one of the states. We are one of the states that does not require a residence, that you be a resident. So they tend to come to states that don't require a social security number and don't require a residency. And we're one of those states.
Because we've had several of them. I just thought maybe they're recruiting to live and work here. I didn't know why they were testing here. So thank you.
Well, I'll add to that, and I'll defer to counsel, of course, but proof of gainful employment helps when you have a license registered. So,
Thank you.
I'm going to say also the jurisdictions, since we've got jurisdictions other than states.
Right. So there's 55 licensing jurisdictions. Correct. But yeah, there's a handful of states that folks that are international that tend to go to.
I think
We are, most states, I think, reciprocate with us, right? So that they're.
Yes, all 55 jurisdictions do reciprocate.
Yeah.
Yes.
So it makes sense to pick up. Okay.
Well, I've noted some of these are individuals are testing in Guam. I remember there was some discussion that they could test in another jurisdiction that still be registered as a Tennessee
Right.
CPA?
Right. So what they
Okay.
do is when they have their education evaluated, they do it or request it to be done according to a specific state's requirements. So this individual looked at the requirements in Tennessee and asked to be evaluated based on our requirements. And so they've chosen a jurisdiction to test under, but they could test anywhere. So they could test in California, they could test internationally, they could test anywhere they wanted to, but they're testing under our jurisdiction.
Thank you.
Other questions? All right, seeing none. Karen?
Sam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon, Rob Vance.
Aye.
Right. Those are all the extensions of credit that come under that category, but we do have a request to extend exam scores, and this is Bay Fund. This is similar to some requests we have received in recent years, where people passed all 4 parts of the exam, did not get their license, and we have a rule that says all CPA exam scores shall expire 10 years after the first passing score is. However, upon written request by the applicant, the board may, in its sole discretion, grant an extension of the score expiration date for so she has said that she did not pursue the actual certification because her career turned out not to need it, but she's now thinking about going into consulting, and she thinks certification would be advantageous. And so she would like to get an extension and actually become a CPA. We have had this. Should I go into why the rule was implemented? Wendy, is that, or is that just an aside?
I think that's just an aside.
Okay. All right. Well, anyway, it does look similar to ones we have approved, and we've generally approved these. The only thing that stands between her and certification, that has ever stood between her and certification, probably, and I don't have her file, probably was the open book ethics exam, and then, of course, every so often she would have had continuing education since that time. But where did I? Hold on. We have a chart that shows various cases. So in July 2021, the date of the first exam was 1994, and we extended the scores until assigning CPE and specifically ethics CPE. So I don't see a difference between her request and others. I don't know if her situation is real different from having been inactive. She didn't go through that last hurdle, but I don't see her as any more risk to the profession than someone in that situation. So I would move that we would extend
Dr. Church, I would encourage you to discuss if you want to approve an extension, is that for a specific time or for she have a specific, but
looks like we granted a year when we acted in 21. That's the only one I think that we have the dates on, isn't it? Does that seem reasonable?
Yes. So in this particular situation, we are not sure if the education requirements of this applicant meets the current education. I believe it does. Because,
She's under the impression it does, I assume.
well, she understands she needs to have her education evaluated, but she did not want to do that until she heard from the board on whether the board would be willing to extend the scores.
Okay, and then also we might require CPE as one of the requirements. So
So what's your motion?
my motion. I move that, well, let me ask, can I ask Wendy a question? If we required, say, 80 hours of CPE, is that feasible in a year? I mean, I know it's feasible. We can do it, but I mean, is that in keeping with what we generally would ask?
I mean, an 80-hour requirement is typical in a 2-year period, so I don't think there's anything wrong if you want to. That would probably keep it from coming back to you. You know,
So
if you
perhaps a 2-year
you gave her 2
extension
years
with 80.
to have her education evaluated. Let's say she came up short.
That's another delay, yeah.
Then she'd need to take
That's a good
something
point.
and complete the CPE, and likely she
Probably
will
with
do
2
it in
hours of
advance of
ethics.
that, but that would
Okay.
give a window, but yet not leave it open forever.
Okay, here's what I move. I move that we extend the scores for 2 years and require 80 hours of CPE, including 2 hours of the board-approved state-specific ethics.
I'm sorry to get specific here, but when we say 2 years, let's give a date because the scores expired a long time ago, so we don't want it to make it sound like we're giving 2 years.
I think it would be 2 years from today.
Okay, that's fine.
Or tomorrow. Should it be tomorrow because that's the official date?
So yeah, 2 years from tomorrow, and probably
31st.
and probably clarify that it's all technical CPE because that's a requirement of a reinstatement
And
or a
that's
reactivation.
That's what our previous case was. 80 hours of CPE. Well, let me go back. The date would be January 31st, 2025, provided that she provided 80 hours of CPE in technical subjects to include 2 hours of board-approved state-specific ethics is submitted with the license application. Education is.
I was going to say, should we say provided she passes the education review? We're talking about the 150 hour.
So I don't know that that's necessary because we can't issue her a license.
Rule.
It's a separate requirement. So this is about her exam scores, and if she doesn't meet the education, she's not going to get a license. So I don't think it needs to be part of this.
Because when we say education, we're talking about her college education.
Correct.
Okay.
Correct.
Verifying that.
Correct.
But in the 2005, or she started setting in 2003, did we have the 150 hour requirement then? I don't recall.
Did, but the number of accounting hours was different.
Oh.
What about the ethics exam? Was that part of it back then?
No, I don't know for sure. It is now, obviously, and she'll need to do that.
Wendy, this is Janet. Did I hear you say that this requirement that we're proposing is the same as what an inactive candidate would have to do to get their license active?
The CPE part would be the same as what an inactive individual would need to do to reactivate their license. Yes.
Yes. Okay. Yes.
Is the 80 hours of CPE required in order to get a license?
It is not.
No, but in this case, would it be?
To me, I see it as a requirement to accept the scores, not to issue the license.
So she could apply for a license next month.
Right.
And if she did the ethics and the education was good, she could get her license.
I think the way I see it is that you're only approving an extension of the exam scores if she gets the 80 hours of CPE.
That's what we did on the 2021 case.
I don't think it's necessarily part of the licensure requirement. It's a part of you all agreeing to extend the exam scores. I'm not sure we can make it part of the licensing requirement.
I think it's sort of a compromise because she would have been doing those CPE requirements if she'd been an active certificate holder. And we're not trying to be totally equivalent, but it's just saying this is what we're offering if we're going to make that concession.
I'm not on the committee, but the fact that since 2003 and 2005, there's been a lot of changes in our profession, so I think it's logical.
Mm-hmm.
Do I have a motion? Do I have a second?
Second.
Okay, so motion second. Any further discussion? Karen?
Pam Church.
Aye.
Janet Booker Davis.
Aye.
John Griesbeck.
Aye.
Gay Moon. Rob Vance.
Aye.
Chairman, could I ask a question?
Yes, sir.
I'm going to go out on a limb here, but over the last 8 years, we've had various proposals similar to this, and they've all been approved. I don't remember any that have not been approved. So do we need to consider a rule change that would allow this kind of thing not to have to come before the board every time and put stipulations in there as to what would allow that person to have their scores reinstated, such as catching up CPE and doing various things? Just have a rule that would allow that to happen, because it doesn't look like we've ever. I mean, if you think about it, when I was reading this, I was thinking, what would be different about this case that would cause us not to approve it?
It would be if it was not before the flood. All these people, these people didn't know that rule wasn't in place, the 10-year, and so they didn't know.
Let's put stipulations in the rule that allow it to happen, assuming this, and this. I mean, the more things we can keep from coming before the board, the better off it makes.
Well, and I think that rule, if it was put in as a matter of sort of practicality because of lost records are much more backed up because they're virtual these days. So it's really not as relevant as it was back then. We have now seen two very similar cases and voted for two identical provisions. I think maybe those provisions would be what we would require.
We really only had 8 cases in 9 years.
Well, and I have known someone who just sort of out of assumption did not come forward and ask, because she thought, no, I let it expire, and she felt she was ashamed of herself, and so she didn't come ask. So if it's really something where we are pretty much going to approve it, I think we're doing a disservice not to have a blanket rule on the books.
Thoughts? Kevin?
Just a question to Wendy or legal counsel. Knowing the machinery of getting a rule change passed and the kind of at least the year-long time frame that would typically take, is there a way to administratively deal with this in a board policy way rather than a formal rule setting?
I'll make a comment and then let Sveta agree or disagree with me. But if you wanted to give me authority to approve these, I think that would be fine. However, if you're having stipulations, that's where it gets kind of rough, because the licensee or the public needs to understand exactly what's required. And so if you just wanted to approve these, if they came in, then you could give me the authority to do that. If you want to add stipulations to it, I'm guessing Sveta's going to say that we need a rule change to do that. But
Yes, that was exactly what I was going to say. I think that every board and commission is different, and some have given their executive director all the authority, and some have not. And in this case, it will really depend on what authority you want Wendy to have on your behalf. So, but if it's something where you wouldn't feel comfortable unless you know all the facts, it may not be as beneficial and efficient to do it that way. So maybe a rule change is better. Or maybe Wendy can have the directive that if this happens, this happens, this happens, it's this kind of a case, then you can go ahead and on our behalf approve or not approve. And then, so maybe some go to Wendy, maybe some come back to the board. So that might ease on the volume of cases that you see. That's an option. But other than that, I would say perhaps a rule change is the best way.
Well, first of all, I would say I would defer to Wendy's judgment pretty much on any case. But the question I have is where is this rule written? I mean, where does one look this up in order to see what the requirements are?
It's listed in the center of this page, but it is part of our rules, so you can find it on the website if you go to the law and the rules. But in the center of the page, the relevant rule is Chapter 1, Section 6, 11, under examinations. All scores expire 10 years after the first passing score is earned. So
pretty plain, yeah.
Yeah.
Okay.
Yeah.
I'm at least as concerned about people knowing about the policy as I am about our not having to handle them. I'm more concerned about the people knowing about it. So I would think maybe we should go forward with the rule change, but in the meantime, allow Wendy to have the authority to approve them between now and then.
Also, I don't have the information in front of me, but I did research it, I believe, last time that we approved one of these. A majority of the states do not expire their exam scores. So sometimes the avenue for folks is, well, maybe go to another state. And so, we always look to be consistent with other states. So it wouldn't be unprecedented to either get rid of the rule or modify it in a way that makes more sense.
When they go to another state, are they required to do the 80 hours of technical?
Not if it's not in the rules of that state.
I would think we could.
That would sound to me like the path of least resistance from a rule change perspective anyway.
Appeal the rule.
Mm-hmm.
So what I could do, if this is what the committee and or board would like to see, is we could just do some research and bring you back some information on exactly how other states handle exam scores, so that you have more information and decide whether you want to repeal or whether you want to reword it in some way.
Before 2014, they just didn't expire, and you could just come forward in time. And that was more of a practical consideration because there were lost records in the flood.
I was just going to say, I think it's, unless somebody else, I don't think we need more research. I think we could just move ahead and not wait till the next board meeting, unless I'll defer to everybody else, but I know I feel that way.
I think sitting here, I kind of feel like that we should look at it compared to what other states do and see if we're comfortable with somebody who's got a 20-year-old education who has, nothing really up to date about the changes that have happened in our profession. And I really think the changes from this point in 20 years from now are even going to be greater. That we kind of look at that and discuss that, and then if we decide not to do that, where we enforce maybe an 80-hour technical hours once you get to a certain level. But that what Wendy's going to do with the research from the other jurisdictions and states is kind of tell us what they're doing, what they see, and the reasoning behind it, and then we don't have to do it that way, but at least we'd have it in front of us, and somebody can't say, well, we didn't know about that. So
okay, I was thinking that we already had something in place that would require that kind of technical, but maybe we don't.
I don't think we do. We're adding it in because we think they should.
All right, my bad on that. Yeah, because that's definitely an issue.
In the meantime, and to Pam's comment, there could be others. Is there a way to sort of, quote, advertise this rule if there's some others out there that might be interested? It couldn't come out of Tennessee State Board. They're not licensees, right? Tennessee Society, not sure that's even the right way. So I'm not sure how you get the word out about this.
That's difficult. Now, we could do something in the spring newsletter where people like you might see it, and maybe you know someone in your firm or that you've worked with. It's a chance that people would see it.
I mean, while we're all looking, I mean, you got the AICPA, NASBA, and everybody else trying to create more pipeline activity. I mean, this is not going to make a flood of applicants or anything, but I think it would create a few, and it would remove one more obstacle to becoming licensed for those that are out there that took it years ago and are thinking, gosh, there's no way they would approve this now.
I like the tone of it. I like the tone that it expresses. I will say the rule, I mean, I realized I went from saying, yes, let's look into a rule that would require CPE to let's rescind the rule. So let me just point out my discrepancy there. But the rule does currently say, however, upon written request, the board may grant an extension. So at least it does throw that out there, which it does at least offer some encouragement. But I would like to see us put in what Larry had proposed. Right now, I'm leaning that way because I'm combining what both of you said. So I like to do research. That's the bottom.
Well, then I would say that just reading the committee here, Wendy brings back some information, and let's talk about it at the next meeting, and let's just come back with a plan. All right. So we had a motion. We had a second. We've had discussion. I'll ask a third time. Is there any further discussion? Seeing none.
I thought we voted.
Did we vote? Okay. All right. Good.
We've already voted. That was different. Larry brought up the rule change afterwards. So
that was when I said, "Can I go out on a limb?" After you already voted.
I'm back out on the limb.
So, anything further?
Yeah. Finished.
Chair, Church. Okay. All right. Enforcement. Chairman Monroe.
Thank you, Mr. Chairman. We have two items on the enforcement agenda. One is an information item only, which is the presentation of the case and complaint report that was included in our read-ahead packet. Probably the item of note there is that there are a number of cases here on the report that are subject to investigation being needed, as noted, and that's probably we're gonna begin to make some headway here with our new investigator. And Wendy, if you would like to introduce our new investigator, this might be a good time to do that here.
Sure. Happy to. Duke Speed is with us today. He started just this past Monday as a result of you all appointing him at the last meeting in October. So I will just let him openly introduce himself and maybe give a little bit of his background.
So, good afternoon. My name's Duke Speed. That is my real name. I have my birth certificate in here. I can prove it to you. So I just recently retired from the FBI. Spent approximately 21 years there as a special agent. Prior to that, I was an accountant. I had a CPA license out of the state of Maryland. I was in kind of the corporate side. I worked for the Walt Disney Company. I was a controller for a small little division inside the parks called Disney Regional Entertainment. Did that for a number of years, wanted to make a little bit of a career change, and decided to join the Bureau. I thought for sure, this was at the time Enron was happening, WorldCom was happening. I thought I was going to be sent to a very large office and work corporate frauds. I was sent to McAllen, Texas to work transnational organized crime, which is a fancy government term for drug cartels. So that was interesting for me. I did that only for a little bit of period of time before the management decided I did have a CPA license, and let's kind of optimize that. And so probably in the next 15 or 16 years, I worked exclusively what we call white-collar crime, corporate fraud, financial institution fraud, investment fraud, healthcare fraud, public corruption, civil rights. And recently became retirement eligible and decided to make a little bit of a career change. And so applied for this position. Happy to be here.
Wow, you certainly got the credentials. Welcome.
we're glad to have you. And oh, by the way, we're going to have you do this again tomorrow when we're on the record for the actual meeting. So,
Yeah.
But we'll get a repeat then.
The next items that we have in our committee are the legal report cases with recommended disciplines, and so we'll go through those as a committee. And typically, what we do on the consent agenda cases is we have one motion for the consent items, unless there's a request to pull those out. And so I'll go through the consent items first, and then we'll proceed to act on those. The first item is case number 2022-04-5861. And this basically relates to communication between a client and the respondent with respect to expectations on tax services. Subsequent to the filing of the complaint, things were resolved as between the respondent and the complainant. So the recommendation here is for closure. Case number 2, which is formally case number 2022-04-2631, is a case whereby a complainant alleged that the respondent was fraudulently and intentionally diverting funds from their former employer's account. That turned out to be an error, and in fact, the respondent did have the permission to transfer the funds to the appropriate accounts. That was resolved, and so the underlying basis for the complaint has been resolved. However, the respondent did not respond to communications from the board and from counsel's calls for some period of time. And so we are recommending here that a letter of warning be issued to the respondent regarding that person's duty to respond to requests from the board within 14 days per established board rule. Case number 2022-037601 is a case where there is a complaint. This was actually opened by the board regarding the respondent's use of the term accounting in their firm name. The respondent indicated they did not intend to deceive, but registered their company in the wrong category. They further indicated they don't hold themselves out as a CPA. And then after they were advised of the concern, the respondent immediately took steps to change their firm name with the Secretary of State on their website and in email in compliance with the relevant statute. So because of that cooperation, the recommendation here is for closure of this complaint. The next and last item in the consent agenda is case 2022-04-6941. This also relates to unlicensed activity, and the original complaint alleged that the respondent had been running their deceased father's CPA firm without being licensed as a CPA, and also that the website associated with that deceased father's CPA firm was still up and that there was still physical signage outside their office. The respondent indicated that, yes, their father had passed away in May of 2022. They did, in fact, touch base with the board staff to close the firm license, and they were continuing to operate their father's business until forming their own later on in 2022. They also indicated that they had informal agreements with other CPA firms in case their clients needed a test work performed. Regarding the signage and website allegations, respondent indicated that due to a supply issue, it had taken them a while to change out the signage, but that has now been done. They also indicated that the website remained up because their domain was attached to the servers, and they state that they will have the website issue fixed within 30 days, and further stated that they never held themselves out to be a CPA. They have provided the board staff with information confirming they did file for their new business name, and a drive-by was held noting that the signage on the respondent's father's CPA firm had been removed and replaced with the respondent's new name, and they have confirmed that they are in the process of removing and shutting down their father's business website. As a result, the recommendation by counsel here is for closure of this complaint. So those are the 4 complaint items on the consent agenda for the legal report. this point, I would make a motion that we accept the recommendations for each of the 4 items, and then ask for a second, and then we'll have discussion.
I'll second.
A motion and a second. Is there any discussion on any of these 4 consent agenda cases? Hearing none. Karen, will you please call the roll?
Kevin Monroe.
Aye.
David Crenshaw.
Aye.
Greg Gilbert.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Thank you. That motion passes, and we will make those recommendations to the full board tomorrow. The next section for the legal report is the proposed discipline, and here my understanding is that we may have an update on one of the proposed discipline cases. And so, Saveta, if you brief the committee and the members here on that update.
Correct. And the update is actually on number 6. So if you like, we can get to number 5, and then I can touch base on number 6.
All right, we'll do that. So we will, let me get my paperwork in order here. And we'll go to the first proposed discipline case, item 5, but specific number 2022034181. This is a case regarding using the term, a term reserved to licensees in their title or designation. The complaint was filed by a member of the public, and it alleged that the respondent's firm name and website contained the term accounting without being properly licensed with the board. They made reference to the respondent's website and LinkedIn page, which confirmed the respondent's use of the word accounting. The respondent has not responded to the complaint despite the letters that they were sent, and based on the review, the council believes that this is in violation of the relevant rule. The recommendation here is to authorize a formal hearing with the authority to settle via a consent order, requiring the respondent to remove the term accountant or accounting from their firm name, website, and all other sites pursuant to the rule as it pertains to title or designation. So with that, I'll offer that motion. Is there a second?
Second.
We have a motion and a second. Is there any further discussion on this case?
I have a
Yes.
question. How do we have the authority to do a formal hearing? Was there an underlying individual that had a CPA license? I didn't think.
I'll ask counsel to respond to that.
Well, it's an interesting situation where we can get the process started, but it doesn't mean that anyone will show up to a hearing. And so that's the best that I can describe it at this point when someone is not actually a licensee. But this is standard discipline that we've taken in the past with people that are not licensed with us that still need to be brought into compliance. It really, for the most part, we normally get to talk to people, explain the situation, and they're, really open to fixing it, and we don't ever have to get to this point. Unfortunately, this specific person and this specific firm has just been absolutely unreachable. From our staff, from me, I've made attempts for over a month. And so I would hate to not do anything at all. And again, there's no civil penalty. I think the civil penalty might be really big question mark here, but just requiring someone and asking them to do that really in a formal way through a consent order, I think is the most appropriate action, even though they are not a licensee.
Trying to get their attention to where they would stop. Okay, and this is going to get their attention, hopefully. Okay.
But if they don't respond at all, do we send like a cease and desist order? I mean, how does that work?
We can, if it gets to the point where we don't hear anything and they continue to be in violation, I believe that there is a way to escalate it and even get a judge involved, and get this going. But so there is a route to go. We've never really had to resort to it, from what I know. So I'm really hoping we don't have to, but there will be a way.
Any further questions or discussion? Okay, Karen, will you please call the roll?
Kevin Monroe.
Aye.
David Crenshaw.
Aye.
Greg Gilbert.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Thank you. The recommendation for that case passes and will be recommended to the board tomorrow. Now we'll go to case 6, which is 2022043601, and I think, Sveta, you have an update on this case.
Correct. And this is a case. This case is identical in the sense of the violation as the previous one. The only difference here, and as I indicate in the legal report, I had been in communication with respondent's attorney, who was supposed to talk to their client and see if they would be willing to take down the name and change it. And I had not heard from respondent's attorney until this morning. So respondent's attorney emailed me this morning saying they had been sick for most of the month, have not been able to work, and so now they're finally back on their feet, and has indicated that they've talked to their client. Their client is willing to go ahead and comply and do what they need to do to remove the terms from their website, from their firm name. The only thing with that, generally, before I recommend closure, like we've seen in some of the consent order items, I request some kind of proof. So currently I don't have any proof because this just happened this morning, but I want to make you aware that they're willing to change it and they're being cooperative, and it was not really a fault of the actual respondent that we have not been hearing back. So I would defer to the board for discussion on whether we want to change the discipline on this.
So thank you for that update. So it sounds like the current recommendation in the proposed discipline is to authorize a hearing with authority to settle via consent order, requiring the respondent to remove from their firm the term accountant or accounting in their website and all other sites. That's what's on the table. It sounds like there's been positive movement by the respondent's attorney on behalf of the respondent, but we just don't have it concluded yet. So one option, it seems to me, is to continue with the recommendation as is, with the expectation that they would sign the consent order and do their follow up and comply with it, and then that would be the end of it. Would that be a rational way to proceed?
Yes, and I believe that we had a similar one last board meeting where it was same situation. We sent out a consent order and they have worked on complying with it and been sending me proof and all of that. So I think that this will be appropriate. I wish the timing worked out better for the respondent, but it's just really out of our control. Now if I get in touch with it, I just don't know that they can send me proof in in less than 24 hours about actually getting the process going, because it does take quite a bit. You have to change it with Secretary of State, and I know they're, I think, 8 to 10 weeks behind right now. So
could we defer it to our next board meeting? Not tomorrow, but
yes, but I don't know that this is really one of those cases that would be worth doing that. So what Wendy and I were just discussing is, what about, and I've seen it in some of the other legal reports, we amend discipline to where we keep the first paragraph as is, but then we add a sentence that says, in lieu of a formal hearing or in lieu of consent order, respondent will be given a certain set of time to provide proof, and then if they provide proof by that time, then we won't go forward with a consent order. With that, I think that might be very effective, and we can deal with it now and not have to pile it on to next board meeting.
That sounds actually plausible. From my perspective, I think would a reasonable time, let's say, be 4 months, given the backlog at the Secretary of State's office that was alluded to earlier?
I would say so.
Okay. So I don't think we have a motion on the table with respect to this one yet. So let me offer up a motion and see if we get a second, and then we'll have some discussion on it. So in this case, the recommendation would be, as stated in the legal report, with the addition of the following: in lieu of a formal hearing, with the authority to settle via consent order. The respondent is granted 4 months to provide appropriate evidence of compliance with the rule regarding the usage of the term accounting and accountant, pursuant, I guess, to TCA Section 62-1-113.
Second.
Okay, we have a motion and a second. Any further comment or discussion on this one? All right, Karen, will you please call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Greg Gilbert,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Motion passes. The last proposed discipline item is a case that was opened by the board upon receiving notification from the Department of Justice that the respondent had been indicted on charges of conspiracy to commit bank fraud, as well as charges related to a multi-million-dollar scheme to defraud financial institutions. Our counsel has been in touch with the respondent's attorney, who has agreed to provide updates as the case progresses. Given this type of a complex case, the counsel is recommending that this be placed in litigation monitoring, which is typically what we would do in this type of a situation. And so that is the recommendation for board's consideration. Is there a motion? I'll make the motion to that effect, to place this in litigation monitoring. Is there a second?
Second.
Thank you. Is there any further discussion? If not, Karen, will you call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Greg Gilbert,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
That motion passes. The last item that we have in the legal report is a representation. This is case number 2022027311, and essentially, typically we have a representation in a situation where there is new information that's come to light that might cause the board to revisit its previous action. In this particular case, there is really no new information regarding the underlying complaint or facts around that. What is new here is that the counsel for the respondent has subsequently submitted a counter settlement offer, which basically would increase the recommended civil penalty from what the board had recommended before, but decrease the recommended length of the suspension. The board previously approved a 24-month suspension. The counter offer recommended a 6-month suspension. And then it still agreed with the notion of completing the 3-part NASBA ethics course. The other new information regarding this was that the respondent's attorney shared that during the time of the transactions, the respondent had developed some alcohol problems and had taken proper actions in addressing their alcohol issues. Furthermore, clarification around the date range of the transactions that was previously indicated to have occurred between February of 2020 and May of 2021. The actual fraudulent transactions occurred between September of 2020 through February of 2021, so some change around the date window there. Council is not really recommending a new recommendation and is not recommending that we accede to the counteroffer. And Savetta, do you have any further elaboration?
Yes, one thing that it didn't make it in on time for me to put in the legal report, but I did receive a letter of like a reference type letter from the mayor of the town where respondent is from and where all of these fraudulent transactions occurred, and the letter was very complimentary of respondent and obviously in support of respondents keeping their CPA license, and just the letter confirmed that respondent had been having a really hard time trying to manage between their own practice and all the political tension that was going on, and while serving as a county budget director, And so I just want to put that on the record that we have received a letter of reference from the mayor. But as far as my recommendation, my recommendation has not changed. I don't know how many of you remember, I'm sure Larry does, but I tried to recommend 12 months of suspension, and the board was not really okay with that. So I think, and me and Wendy have gone back and done some research as far as how have we handled similar cases in the past, and this is pretty consistent. So, and another thing that, probably to look at the transactions, I mean, the time period really is now 6 months that all these transactions occurred between, and not, over a year as originally listed. So, but, I wanted to present all of that information to the board and see your thoughts on it, but my recommendation so far has not changed.
Excuse me, is this the case we discussed, Wendy? I don't see the name on here, the one that I needed to recuse myself from?
No, that's tomorrow.
Okay, I'm sorry. Excuse me. Thank you.
Okay. So I'll just start off here with a commentary real briefly here. The board actually acted at its last meeting, I believe, to basically arrive at the discipline that was originally stated, which was a 24-month suspension, I believe a $5,000 civil penalty. And, in my view, what we have here is a municipal official that who is a CPA and was behaving fraudulently. And so I remain very comfortable with the discipline that the board approved at its last meeting. I don't recall during my tenure on the board when we have a CPA who is committing fraud, and particularly a public official, where we've ever tolerated a 6-month or less period of time for a suspension. And I don't think this is the case to start doing that. So my recommendation is that we make no change in our previous discipline. And that recommendation was the committee recommendation from the last meeting that was ultimately approved by the board, which is for a 24-month suspension, a $5,000 civil penalty, and the required completion of the 3-part NASBA ethics course. Now, I guess one question to you, Savetta, is given that we're not changing our recommendation from the prior meeting, is any action necessary on the board's part at all at this meeting for this item?
I don't think so, because there's no new committee recommendation, and mine has not. The overall recommendation has not changed from last meeting. I think we have enough on the record. This now just goes back to me to communicate with respondent's attorney, and just to continue moving the case forward.
Before we close out on that, though, I just want to give board members and committee members a chance to weigh in with their thoughts here in case there are different views.
I'd agree with you, Mr. Committee Chairman, on sticking with our original recommendation.
I agree as well. I just wonder if we need to, just to kind of put some more backbone in it, to have a vote that we stand with our original decision, and she can tell the respondent's attorney that we revisited again, and that is our position.
I mean, I'm fine with that.
I'm fine with that too.
I think it would be helpful.
It won't hurt. So,
Savetta, I have a question, and I am in agreement with leaving the penalty as is, but the last sentence of the first paragraph under the new information baffles me just a little bit. Not an English thing. It's is this like an offer in compromise or negotiation or something? Because respondent's attorney subsequently indicated they're open to any revision of the time period. So we were at 24 months and they came back with 6 months. So is this, are they trying to negotiate? Is that?
Right, because I had indicated to them, and they had not watched the meeting. So I said, if you go back to the meeting and watch it, you see that I actually tried to go with 12 months, and that was a no-go. So 6 months really would not work. I can't guarantee that, but I just said, it's hard for me to believe that they would go for anything less than even 12 months. And so at that point, respondent's attorney indicated, anything, we'll be open to anything under 24 months. Just 24 months is a really, really long time. And so I wanted to be fair and just indicate that, it may seem like a very shocking counteroffer, but they understand that and they're willing to accept really anything that you may give. So,
Chairman, I would
go ahead.
I would add that I remember this case very well, and one of the things we talked about, and I think I actually brought it up, was, one of the responsibilities we have is to protect the public. And this person was not stealing from his employer in a private entity. This person was stealing public money, public governmental funds. And I think that 6 months would just be a slap on the wrist. And I think I totally agree with our chairman that we should leave it as it is.
And when you mentioned earlier that you had gone back and researched previous cases and that it was in line with that, were you talking about the 12 months or the 24 months?
Or the 24 months.
Okay, I fully agree. I can't see it being any less than that.
Is this individual in public practice also? And he's a county official, controller or something like that?
Well,
Okay,
at the time, from my understanding, the arrangement was that they're able to keep their own private practice while serving as the county budget director, and
It's a part-time job then, sounds like.
right, and the pressure ended up being a lot more than anticipated, and obviously these kinds of jobs are very political, and I think it was a difficult time for the county, and
But he is in public. He is in a
Correct.
public CPA practice.
Mhm,
Okay.
correct.
Well, I see why the time period is troubling to him then.
Mr. Committee Chairman, if it's appropriate, I would like to submit the motion to reaffirm the original decision of the board as far as penalties and suspension.
Is there a second to that
Can
motion?
I second?
If you're a committee member, you can, yes.
Second.
Okay. So now we have a motion and a second. Is there any further discussion?
It's a board vote or a committee vote?
This is a committee vote, and then the board presumably would take action to have the same approach tomorrow if it so chooses. Okay, Karen, will you please call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Greg Gilbert, Gay Moon,
Aye.
Rob Vance,
Aye.
Thank you. That motion passes, and that concludes the legal report, Mr. Chairman.
Thank you, Mr. Chairman. Appreciate it. Great job. Now we have a break. Okay. Let's take about a 15-minute break.
This meeting is being recorded.
All right. Thank you. Welcome back from our break. Now the executive committee, I will ask Wendy to go through our travel and financial statements.
Actually, Mr. Chairman, I'll start off. The first thing on the agenda is we did ask the TSCPA to make an update related to the peer review program. I think when you and I initially talked, we were going to do that on the board meeting day, but with the items we added to that agenda, we moved it to today.
Okay.
So we have representatives from TSCPA here today to give you all an update on the peer review program. So they can go ahead and come up.
Good afternoon. Can y'all hear me okay?
Yes.
Thank you for having us. For those of y'all who I have not formally met, my name is Katie Cheek. I'm with the Tennessee Society of CPAs. I'm the COO there, but I also work directly with our peer review program. So I'm here today to give you guys an update. Some of this is repetitive information that you may remember from prior years, but it's always good to have a refresher. And then some of it is just some updated data and statistics related to the program over the last year. And I believe you have information on your iPads that you can refer to as I'm going through this. Going ahead and getting started, I'll kind of walk you through who we have on our staff that relates to our peer review program. Kara Fitzgerald is our CPA on staff and also serves as our CEO, as all of you should know. But every administering entity that administers the AICPA peer review program is required to have a CPA on staff to oversee the operations. So Kara oversees that for us. In addition to myself, we have Gina Carrata at our office who serves as an administrator. We have Art Sparks, who many of you know, as our technical reviewer. And then Richard Hill, who is the current peer review committee chair, also serves as a backup technical reviewer. I also wanted to introduce Sarah Hardy, who's with us today. She's a peer reviewer and a member of our peer review committee and is here as a representative of that committee. Going right into the first set of data that relates to our firm enrollment. Currently, there are 493 firms enrolled in the program. That is a slight decline from prior years. We have really seen a steady decline of about 6% each year over the last 5 years of firms enrolled in the program. Reasons for that are a little bit varied, but primarily what we're seeing is firm mergers, resulting in a fewer number of firms, retirements, and then firms choosing to no longer perform work that is subject to peer review. This is not a situation that's unique to Tennessee. This is something that's being seen among administrators across the country. 44 of our 493 firms are no ANA firms. That means that they are not currently performing work subject to peer review, but they have maintained an enrollment in the program. So they are annually required to acknowledge whether or not they're performing work. If they are, they're assigned a peer review due date and have a peer review at that time. Moving on to the next data slide here, we have some information on engagement reviews accepted in 2022. We accepted 122 total engagement reviews with a 77% pass rate, 16% pass with deficiency, and 7% fail rate. This reflects a slight increase in non-pass report ratings as compared to information from 2021. Looking at national data, I tried to pull some of that to compare how Tennessee is measuring up based on the performance of other states' data. I don't have information from 2022 for comparative purposes, but from 2021, there was an 82% pass rate. So TSCPA firms in 2022 are not substantially off base from what's been the national trend. Moving on to the next slide, we've got system review data. So last year there were 62 system reviews accepted with an 87% pass rate, 8% pass with deficiency, and 5% fail rate. For comparison's sake, in 2021, the national data shows an 82% pass rate. To the next slide, we have a snapshot of corrective actions issued in 2022. Just to give you a little bit of background on corrective actions, those are issued by the peer review committee when they're accepting a peer review, and those are taken to help the firm remediate whatever the issues were that were identified during the peer review. You can see the most common one prescribed in 2022 related to the completion of specific CPE, followed by pre- and post-issuance reviews, and I will note that when those are assigned to a firm to complete, they must be performed by an outside party acceptable or approved by the TSCPA peer review committee. The outside party must have the qualifications necessary to perform that pre- or post-issuance review. The same thing can be said for monitoring reports or outside party inspections. In some instances, if there is let's say a pass with deficiency or a failed peer review report, there may be multiple corrective actions issued on that peer review report. So could be anywhere from 1 to 4 or 5 actions issued on that report. The committee really just makes a decision based on, again, the information coming out of that peer review and makes an effort to design actions that will help that firm remediate. Are there questions to this point? I'm going to touch a little bit on firms coming out of the peer review program. what may lead to that, and what those processes are. So the first type we're going to look at is called a drop. A drop occurs when a firm has not cooperated in one way or the other with the standards of the program, and the peer review has not yet commenced. So in other words, one example would be if a firm is due to have a peer review, let's say by February, they never schedule their peer review. They go through a series of, they get letters that they receive, reminders every so often, let's say every 2 to 4 weeks, they get a reminder. If they do not schedule their peer review, eventually they are dropped. Every drop is presented to the AICPA peer review board before it occurs. Anytime a drop occurs, the TSCPA notifies the State Board of Accountancy. Happened. So firms can reinstate into the program after a drop. If they wish to reinstate, they have to remediate whatever the issue was that caused it. In other words, if they've not scheduled their peer review, they have to schedule their peer review. If it's something like they haven't paid an administrative fee, they're required to pay that fee in order to reinstate their enrollment. When a firm reinstates, if they've passed what would have been their peer review due date, they're given a new due date. Second type of scenario where a firm might be removed from the program is called terminations. These are a little bit different in that anytime a termination occurs, you know the firm's peer review has commenced. So several reasons as examples that a firm might be terminated from the program. Let's say they begin the peer review and then they just stop responding. They don't provide the information necessary to finish the peer review. That may lead to a termination. Same thing would go if they finish the peer review and they are assigned corrective actions and they fail to complete those. That could result in a termination. A couple of other reasons may be if a firm has consecutive non-pass reports. Let's say they have 2 or 3 fail reports in a row. There's a process that the committee follows that may lead to termination of that firm's enrollment, and we'll talk a little bit more about that in just a moment. When a termination occurs, the process is a little bit different. The peer review committee has to make a decision. They have to review all of the evidence provided regarding that firm's non-cooperation, refer the firm to the AICPA peer review board, who then decides whether or not the evidence is sufficient to call a hearing. If they call a hearing, that hearing panel has the opportunity to either make a case to retain that firm's enrollment or proceed with a termination. If a termination occurs, again, the firm has to remediate in order to be re-enrolled in the program. So for example, if they have not completed their corrective action, they would have to do so in order to be re-enrolled. Anytime a termination occurs, TSCPA informs the state board of that termination, and that is also publicly available information on the AICPA's website. So again, going back to if a firm would like to re-enroll after termination, for most reasons, they can re-enroll through the TSCPA peer review committee. However, a couple of reasons require them to re-enroll through the AICPA peer review board when they have to go in front of a panel to determine whether or not their re-enrollment can be reinstated. So examples of when they would have to go in front of the AICPA peer review board would be if they have consecutive non-pass reports, or if they have had consecutive corrective actions on the same peer review and not shown evidence of improvement. Anytime if a firm is reinstated, TSCPA will notify the state board at that time. Looking on the next slide, there's a slide called 2022 drop and termination reasons, where we have broken out the reasons for drops and terminations over the last year. You can see there are far more drops than there are terminations. The most common drop reason is failure to schedule a peer review, followed by administrative fees not being paid. So that totaled to 35 firms dropped last year. And then for terminations, there was 1 firm terminated for failure to complete corrective action, and then 3 firms terminated for consecutive non-pass peer review reports. I wanted to add on the consecutive non-pass reports, with each of those that comes in front of the peer review committee, they're carefully considering the details around that firm and the peer review reports. So if there is a deficiency that's being repeated across several peer reviews, that may lend itself to a stronger case to refer that firm for possible termination. On the other hand, if a firm is showing considerable improvement from one peer review to another, the peer review committee may opt to give that firm some more time to improve. They may assign corrective actions that are specifically designed to help them improve, to give them that opportunity. With that, I'm going to ask Kara to come up and talk a little bit about oversight of the program.
All for having us today. It's important to us as administrators of the peer review program in Tennessee that you all have a level of comfort that the program is operating in accordance to standards, and that we are holding firms to the highest standards. So I'm going to talk a little bit about the various levels of oversight that are embedded as part of the peer review program. For any of you who have been involved in the peer review process before, you know that a peer review goes through several stages, from scheduling to the actual performance of the peer review, to the submission of the work papers for a technical review, and then ultimately to a review acceptance body, or RAB, for acceptance of that peer review report. And at all stages of that process, there are varying levels of oversight as administered by the AICPA. The first type of oversight that I'm going to talk about is a RAB oversight, a RAB observation. Again, RAB stands for Review Acceptance Body. A review acceptance body is simply a subset of our committee members who meet to review a number of peer reviews at a given time. We typically hold 1 to 2 RAB meetings a month. Every year, the AICPA Oversight Task Force selects RAB meetings in all of the administering entities to observe, to ensure that the RAB members are prepared for the meeting, that they're properly reviewing all of the materials, that as administrators we have provided those materials timely to the RAB, to make sure that we are taking familiarity into consideration, recusing ourselves from meetings when appropriate, and that the RABs are reaching appropriate decisions in regards to corrective action and peer review report ratings. In 2022, TSCPA held 22 RAB meetings, and 3 of those were observed by the AICPA. Each of our observations in 2022 had a clean report, meaning that there were no findings and that they found that we were conducting our RAB meetings in accordance with program guidelines. The second oversight of the program that I will talk about is our benchmark reporting process. This is probably the newest way that AICPA oversights the administering entities. There are approximately 36 benchmarks that we must report on 3 times a year. Those benchmarks cover aspects of the program related to the work that I do as CPA on staff, related to administration of the program, benchmarks related to our technical review process, as well as our RAB processes. Again, we submit those 3 times a year. They're looking to make sure we're complying with established timelines of getting certain activities performed. They're looking to ensure that we are meeting the qualification requirements for our committee, our RAB members, for myself as CPA on staff, and for our technical reviewers. And then looking to ensure that we are adhering to standards related to review and corrective action processes. Again, we report these benchmarks 3 times a year. In 2022, we only had 1 non-compliance that was reported. It was related to a RAB member who did not meet the qualifications. That was quickly remediated, and that has not been an issue since. The next type of oversight is the AICPA oversight. This is an on-site visit that is performed by an AICPA Oversight Task Force member. This happens every other year, and in 2022 was our year for our on-site oversight.
It's really an in-depth review of our policies and procedures. There's a lot of work that AICPA staff does in advance of that oversight task force member coming to our office. They're checking our website to make sure the information we have posted about the program is appropriate. They are reviewing materials and different things leading up to that visit. Once the oversighter is on site, they do interviews with various staff, with our technical reviewers. They observe one of our RAB meetings, and I'm happy to report that our 2022 oversight had a clean opinion, and it was determined that the TSCPA complied with the administrative procedures and standards of the program in all material respects as established by the board. There are other oversight procedures that occur, one of those being what's called an enhanced oversight. This is something that is really handled completely by the AICPA. We are not involved in this process other than by being notified that the AICPA has selected a particular review for an enhanced oversight. What this means is that they have pulled a review. They are going to have a subject matter expert perform a secondary review of that peer review, and that person conducting that review may not be a peer reviewer, but they may be a subject matter expert in a particular area. We don't have a whole lot of reviews that are selected for enhanced oversight, but it does happen from time to time, and when we are notified of that, we kind of put our process on hold, meaning we can't present that review to a RAB for acceptance until that enhanced oversight process is completed. And then lastly, we conduct oversight of reviews and firms. We are required by AICPA to select a certain percentage of reviews for oversight. Typically, that's a committee member who is performing an oversight of a review. We take into consideration a variety of factors when determining what reviews or reviewers we will select for oversight. And typically, because our committee members often are performing these reviews, we will typically or often engage someone from out of state to perform those oversights to avoid any indication of familiarity in that process. So that's just a little bit about, outside of just the normal administration of a peer review, all of the different layers of oversights and kind of checks and balances that go into the program to ensure that we are performing all of the administrative procedures and acceptance procedures in accordance with standards. Are there any questions for me or Katie or Sarah?
Sarah, what are the requirements for having a CPA on staff? And if we did not have one, do we have to look to another state somehow?
There was a period of time, and honestly, because we've had a CPA on staff, I don't know if this is still allowed or not, where states who did not have a CPA on staff could request a waiver for a period of time as they determined whether or not they were going to employ someone to fill that position or not. Many states, for that reason, have chosen to stop administering the program, and they have transitioned their state's firms to another administering entity. I have to comply with certain CPE requirements and experience requirements to fill that position.
Sarah, how many folks serve on the TSCPA's peer review committee? Do you?
How many?
Yes.
About 12 to 13. We've lost 3 in just the last few months, so our numbers are down a bit, and that's an area that we're in continuous, just outreach to try to identify new folks as reviewers and to serve on our committee.
And then those members serve as RAB?
Yes.
So my point of all that is those folks, my recollection at least, is those folks spend a tremendous amount of time, and they're volunteers, and we owe them a debt of gratitude.
You're absolutely correct. They spend a lot of time in preparation of those meetings reviewing materials, and with smaller committee numbers, they now have a larger workload in front of them.
And actually, we owe everybody at TSCPA a debt of gratitude, because I think the relationship that our board has with TSCPA is unique. It's very good, has been for many years, and I think those of us that serve on various NASBA boards see other states don't always have that good relationship that we do, and so we very much appreciate all of you
Yes, you're right. It is a unique relationship that we have in Tennessee, and I'm glad that we've been able to maintain that for so many years.
One kind of question, I guess, or maybe by way of a comment, I would ask maybe Wendy also to comment on this. My perception has been that there has been increasing and better communication about peer review status of firms to the State Board of Accountancy, meaning more comprehensively and more timely than where we were at several years ago, where there was either a long reporting lag or not very much transparency in terms of what could be shared with the State Board. And I guess I'd welcome either of y'all's perspectives on where we're at now, and if you agree that there's been some improvement in that regard.
So, since I've been in this role, most of you know we did add a rule that requires firms to submit their reports and their acceptance letters at the time that they renew their permit. So that's one improvement. We also, through that rule change, required firms to do that through an online portal. And so board staff have access to that portal by which that information is available, and TSCPA is on the other side of that. And so it does make that information easier to obtain. And as Katie mentioned, anytime a firm is dropped or terminated from the program, we receive information from the society. I guess the one question I would have would be on the termination side, well, I guess even the drop side, there have been some instances where the firm that was terminated was not an AICPA member firm. And so those don't get published in the same way. Do they still go through the same process? Meaning, do they go through a hearing at the AICPA peer review board?
They do. So
okay.
We have to agree.
Come on up to the microphone so everybody online can hear. Thank you.
We have agreed that if we are administering the program for non-member firms, that they are subject to the same fair procedures and processes as firms who are AICPA member firms. So if they're not AICPA member firms, if they're not reflected on the AICPA website as a terminated firm, we'll still communicate that as part of our process to you, Wendy.
Okay.
We have to wait 30 days after the termination decision because there is an appeal period. So once that 30-day appeal period has passed, we will communicate that with the board.
Okay, and the firms go through the same process to be terminated, correct?
That's correct.
Yeah, okay.
Thank you.
Any other questions or comments?
I think, Andy, I think we've been trying to do this update once a year so that board members feel connected to the program. Obviously, as part of the law and the rules, we require each firm to undergo a peer review, be enrolled in the program, undergo a peer review once every 3 years. We have the option, the statute says we may oversight any programs that we approve. We have had these reports as part of that oversight process. We can do a more in-depth process by implementing what we call a peer review oversight committee. This board has not done that in the past. Due to this regular communication, I don't think we have felt that it proved any additional information than the updates that we got, but that is certainly something the board could do if they elected to.
From my seat, I think that the TSCPA is doing a wonderful job, and y'all are very much involved and very active, and I think some of the board members up here said it well in the fact that we appreciate your hard work, your dedication, and your members' dedications to the peer review, and we appreciate that very much. As far as my seat, I would say that I'm very much in favor of the Tennessee Society continuing on that in behalf of that and giving those reports to us. I think they do a wonderful job at it, and they help us as a board here where we take on the responsibilities of other things, and it allows everybody to participate at a level. Plus, I'm not sure that I would be qualified to sit on that subcommittee now that I'm not in public practice. But that would really change the kind of the lay of this board too, if we were to have those subcommittees as far as educational requirements.
Typically that's outsourced.
Yeah.
So we create a budget for that, and then we would, contract with folks to do that. Some states do that.
I very much appreciate it. I think it helps our relationship with the Tennessee Society. And as a board, being one of those that's seen the other states that have issues with their associations or societies, that I really respect the Tennessee Society of CPAs and what they do and their relationship with this board. And it's something that I've known for a long time, but it's sitting here on the board, it really is special, and we appreciate it. Seems like we can talk things out between our executive directors or our president for the society, and we can get on the same page on a lot of things. So we appreciate that.
And I feel like the updates and the access to some of the oversight reporting that they have gives us the information that we need to feel comfortable that the program is operating the way that it should.
You're here. I agree with that too. Any other thoughts or comments? All right. Well, ladies, thank you very much. Kara and Katie and Sarah, we appreciate y'all coming and presenting today, and invite you to stay for the rest of the session and as we go through the final segments here. So with that, I will turn it over to Wendy and say travel and financials.
Okay, so just a very short blurb on travel for the last quarter of the calendar year 2022. This is for staff only, so this is my trip to NASBA's annual meeting, and then a trip to Knoxville for TSCPA's chapter meeting to give an update there. So we're back at traveling again, so we'll do these reports at each executive committee meeting going forward.
Fantastic. I know that you were telling me today that Duke is fixing to attend a meeting.
We'll be attending NASBA's executive director and legal conference with me at the end of February. So we are all set to go there.
Great. Questions from travel? All right. And then I don't think we have to have a vote to accept that, but the financial statements, an update on the financial statements, please.
Okay, so you have on your iPads and in your read ahead of materials, we have the financial update for the period ending November of 2022. This is for the fiscal year of June 23. And currently we stand at revenues at $240,845 and expenses at $405,509. This puts us at a deficit of $164,664. This is common this time of year because we have not made our way through the renewal, which is the majority of our revenue. So that gives you the highlights on our net position statement, and I will move on to some of the more specific information. So revenues are up slightly, up 3.8% to the prior year, and this increase is almost totally attributable to an increase in case and complaint revenue. So we are up $8,200 in case and complaint. Our licensing and renewal is almost flat to the prior year. Salaries and benefits are down a bit compared to the prior year. This is largely in part due to the departure of our investigator and going a few months without paying salary and benefits in that area. Of course, we'll pick up there as we are now fully staffed. One important item that I want to note going forward is there was a statewide salary structure overhaul announced in December of this year. So this overhaul is going to add roughly $40,000 annually, or 10% to our salary and employee benefit line items. And so it's going to be significant difference to what we're used to, which is great for the staff. A lot of staff received some very nice raises in December, so we're happy about that. It was all across state government, so it will also ultimately impact cost backs as well. Legal team, other administrative employees throughout the department where we receive cost backs, there were salary increases there as well. So it will affect us across the board. So something that we're going to need to pay attention to. I think it's going to be noticeable. Longevity compensation is down to the prior year, but basically because all we have in there right now is longevity, we don't have any pay for performance or what we call bonus. That money is paid out in January this year, and so you'll see that number rise next time we meet. Travel, obviously, that's quite a bit ahead of last year because we're back to a normal travel schedule, but we are in line with what the board approved with regards to budget. I'm going to jump down to employee training. That is the registration fee for NASBA events. And so you'll see that at $2,085 for the current year versus nothing in the prior year. And that's the difference there, is the registration for NASBA events. And then when you get to state professional services, we are showing an increase over the prior year, 25%. This is largely due to technology, as I broke down the numbers there. About $20,000 of that $32,000 are technology-related items, whether it's our VPN lines or our tickets that we have to put in to have IT do something for us. So anything technology-related falls there and is a bulk of that, and a bulk of where the increase is there as well. You'll also notice that
is some of that related to working at home versus not?
I mean, I would say yes, not to a large degree, but yes, there are some expenses in there for, let's say, VPN, and I'm trying to think what else we need at home that we wouldn't pay for here in the office. But we also have a reduction in rent that kind of offsets that a bit. So overall, I think more of the technology is around our licensing platform, and when we need changes or improvements made there, when we need to update applications within the system so that the licensees see what they need to see and are able to answer the questions that we need them to see, those types of things. So it's the IT group that does that for us.
So is it true, it's my understanding that all your employees, all your staff now work from home every day?
Yes.
And so you don't have any offices in this building anymore?
Do not have any dedicated offices. So it is
have like a hotel concept.
Hotel concept.
Yeah.
So we have an area by which we would go to, and you pick an open spot to sit down and set up for the day.
Charge rent for that.
Correct.
So there is some duplication of IT type things here because of that, home and here.
Yes.
Like some extra computers, or the renting of extra computers.
Yeah, maybe that. I'm not sure how that flows. I've never seen an actual specific charge for that, but
that part of cost backs.
We bring our own computers back and forth.
Oh, okay.
So the monitors and the desks themselves and the actual space, we are paying a bit for in the rent, I believe.
Is it only if people are coming in? Is it pro rata that way, or is it?
I'm not sure exactly how they determine. I think I don't know how they exactly determine it, but it is a fixed rate every month, probably based on our size within the division of reg boards.
And I wanted to ask something specific about the customer service center cost doubled in November over any other month.
Oh.
And do you know what that would be?
So remember that renewals go live November 1st, and so we get more calls that time of year, and so the tickets may double. So when folks call in, and they initially receive someone in the customer service or the call center. If that person's unable to answer their question, they are forwarded to a staff member to help with that. So each time someone calls or emails, it's a ticket that we then are charged for. And in the cost backs, you'll also see a pretty significant increase there. When looking at those numbers specifically, it looks like that increase is really attributed to legal fees. And so I have asked for some more information there on whether it's the number of hours, or is it because of salary increases within the legal department that we're seeing more of a cost there. But mainly the cost backs are increased because of legal fees.
So we can blame Savetta for that.
Correct.
told you you can take your swings today. It's okay.
Actually, I think for the most part, what I've seen, everyone that we interact with are very deserving of those raises that were given. And actually, I kind of wonder, I mean, we have the reserves for that.
Yes.
But I kind of wonder if we're going to get nicked for that in our reserves. Do we have any idea? Not for just, we want to be nicked for our people, but will the other departments be able to take some of our reserves? I know we've been worried about that in the past.
So another department doesn't really take our reserves, but the legislature could sweep the funds, correct? So it will be interesting to see what happens with the salary changes and how much it does affect us, and whether once we're back to traveling full speed and salary increases across the division, how that's going to affect us, and whether we'll go into the red, at year end. I don't know. So we'll just have to watch it closely and see. We have plenty of reserves to allow that to happen for a couple of years. Although when you allow that to happen, you then have to go in front of the legislature and explain why. So just something to keep an eye on as we move forward.
This may sound like a dumb question, but so in reserves, we actually have cash money in the bank, or is that just an accounting entry?
I believe it's more of an accounting entry.
An accounting entry, because we don't. Okay, thank you.
Mm-hmm. I think that completes my report on the financials. If there are any other questions, happy to take those.
Other questions for Wendy? None? Okay. So that wraps up the executive committee. I would remind everybody that we have decided to get together tomorrow at 9:30, breakfast on your own. Please be safe as you travel. And also as you get up and start to get ready, just check for emails from Wendy. Anything further? Well, thank you to all the staff, and thank you, Karen, for recording this and taking care of all our votes. And we will adjourn and come back tomorrow.